Criminal attempt is an Inchoate offense, sometimes called a preparatory offense. You've heard of them before. Offenses like attempted murder or attempted robbery. They are generally charged when a person tries to commit a crime but isn't fully successful or isn't able to complete the crime. Think about it this way. Do we have to wait until you actually kidnap your boss, or can we arrest you before you get to his house with duct tape, rope, garbage bags, and a ransom note in your possession? Law would be pretty ineffective at preventing criminal activity if we had to wait for you to actually commit a crime before we could stop you. By that time, the damage might already be done. For the Inchoate offense of criminal attempt, the Texas Penal Code requires a person to be proven to have a specific intent to commit an offense combined with some sort of overt act that is more than just mere preparation. In other words, we can't make thoughts illegal, so you have to have intent to commit an act and have taken some sort of very distinct step towards committing the act. So in the previous example, if you thought about kidnapping your boss and went out and merely bought rope, this might not be enough. The Penal Code goes on to state that if a person is attempting an offense that may be aggravated, a completed act amounting to more than mere preparation constitutes an attempt to commit the aggravated offense if an element that aggravates the offense accompanies the attempt. That's a lot of words, so let's break it down with an example. Using a deadly weapon in the course of robbing a store will result in an aggravated robbery charge as opposed to just a robbery charge. So if you are arrested in the parking lot of the store with a gun in your hand on your way to rob it, which is an act amounting to more than mere preparation, the state can charge you with attempted aggravated robbery instead of just the lower offense of attempted robbery because of your possession of the deadly weapon. Remember, intent is an important part of the equation and must be proven. Just because someone has a deadly weapon in a store parking lot doesn't mean they can automatically be charged with attempted aggravated robbery. This is sort of a complicated statute, so the Penal Code makes a special effort to close some loopholes. The Penal Code goes on to state that it is not a defense to an attempt charge that the offense was actually committed. This is a little complicated as well. Let's explain it this way. There is a distinct difference between factual guilt and legal guilt. You may have actually and factually committed a crime. In other words, everyone believes you committed it, and you know in your mind you committed it. But the state may not be able to prove it in court you committed it to a standard of proof beyond a reasonable doubt. You may be factually guilty, but not found legally guilty. On a side note, this is why in court you are found guilty and not guilty instead of guilty or innocent. Nobody is found innocent in a court of law. Proof beyond a reasonable doubt is a legal standard for the courtroom and has very little to do with factual guilt or innocence. So, with the understanding of factual guilt and legal guilt, let's take a look at an example to explain that you can't defend yourself against an attempt charge by saying the offense was actually committed. Let's say a person actually and factually entered a home and stole items and was caught. He knows he did it, and the police are confident he did it. For whatever reason, it's too difficult for the prosecution to prove the charge of burglary beyond a reasonable doubt. But they think they can prove the attempted burglary beyond a reasonable doubt, and so charge the defendant with this Inchoate offense to have a better chance at holding him responsible for the offense. The Penal Code states, if this is the case, a defendant can't argue at trial, hey, I didn't attempt to burglarize the home, I actually did burglarize it. Therefore, I cannot be found guilty of attempted burglary. Since even if he made the admission on the witness stand, the prosecution probably couldn't go back and change the charge. In other words, factual guilt is not a defense against the legal burden of proof of an attempt charge. Finally, this statute sets out the punishment for attempt charges in Texas. All criminal attempt offenses in the Penal Code are punished one level lower than the offense attempted. So for instance, aggravated robbery is a felony of the first degree. Therefore, attempted aggravated robbery would be punished as a felony of the second degree. It wouldn't be constitutional to punish someone for their thoughts. After all, you probably think about committing a criminal offense every so often, like fantasizing about punching your neighbor who plays his music too loud in the middle of the night. At the same time, the Texas Penal Code recognizes that there are a few specific crimes that we need to have the means to interrupt before they actually happen, particularly when someone is serious enough about committing them to ask another person to help. The Penal Code states the Inchoate offense of criminal solicitation is committed by a person who, with intent that a capital felony or felony of the first degree be committed, requests, commands, or attempts to induce another to engage in specific conduct that will constitute a felony or make them a party to the offense. Again, criminal solicitation applies only to capital felonies or felonies of the first degree, only the very most serious crimes. To place a safeguard on trying to prosecute someone for their mere thoughts or even just their mere words, the Penal Code states a person may not be convicted under this section on the uncorroborated testimony of the person allegedly solicited except under very certain circumstances. So, the sole evidence against a person in an Inchoate solicitation case can't just be that they asked someone to help them commit a capital felony or felony of the first degree. There has to be other evidence as well. Similar to criminal conspiracy, the Penal Code states it is no defense the person who was solicited is not criminally responsible for the felony solicited, or has been acquitted, has not been prosecuted or convicted, has been convicted of a different offense or of a different type or class of offense, or is immune from prosecution. Once again, you are on your own when it comes to a conspiracy charge, regardless of what happened to the person whom you asked to help you commit the capital felony or felony of the first degree. Also similar to criminal conspiracy, it is no defense the actor belongs to a class of persons that by definition of the offense is legally incapable of committing the offense. This would apply if the person you solicited is a juvenile who is not permitted under law to be charged as an adult or turns out to be an undercover officer posing as a hitman. So this section prevents a defendant from claiming they can't be charged with solicitation because it requires two persons and either the juvenile is legally incapable of being held responsible as an adult or the peace officer wasn't charged. It is also not a defense to solicitation that the felony solicited was actually committed. Once again, it may be difficult to prove the offense was committed in a court of law, but much easier to prove solicitation beyond a reasonable doubt. For example, a husband solicits his girlfriend to murder his wife. The girlfriend puts poison in the wife's glass, and the wife dies. Both the husband and girlfriend are caught. The girlfriend is charged with capital murder. But due to the complexities of the case, the prosecutors don't believe they can prove the murder charge on the husband beyond a reasonable doubt. He is instead charged with solicitation to commit capital murder, even though they could have also charged him with capital murder. At his trial, the husband cannot claim that he cannot be charged or convicted with solicitation to commit capital murder because the capital murder was actually committed. Finally, solicitation offenses are charged one level lower than the offense solicited. So if a capital offense is solicited, then it's punished as a felony of the first degree. And if a felony of the first degree is solicited, it's punished as a felony of the second degree. The final Inchoate offense in the Texas Penal Code is a variation of criminal solicitation. The law goes out of its way to protect juveniles from harm, and so it goes out of its way to define criminal solicitation of a minor by an adult. Now, don't confuse this offense with the sexually oriented offense of online solicitation of a minor. This is the Inchoate offense of criminal solicitation of a minor. It states, an adult who, with intent to commit murder, capital murder, indecency with a child, aggravated kidnapping, aggravated sexual assault, aggravated robbery, a violation of Health and Safety Code Section 481, sexual assault, a felony of the first degree injury to a child, sexual performance by a child, a felony of the first degree criminal solicitation, compelling prostitution, or finally trafficking of persons who requests, commands, or attempts to induce a minor to engage in conduct that would make that minor commit or be a party to the offense, then that actor commits the offense of criminal solicitation of a minor. Just like criminal solicitation, a person may not be convicted under this section on the uncorroborated testimony of the person allegedly solicited except under very certain circumstances. The main difference is that while criminal solicitation applies only to capital felonies and felonies of the first degree, criminal solicitation of a minor may be applied to several other criminal offenses, not all of which are capital felonies or felonies of the first degree. There are also differences in punishments, as we'll see here in a moment. The Penal Code states it is no defense to criminal solicitation of a minor. The minor solicited is not criminally responsible for the offense. The minor who was solicited has been acquitted, not prosecuted, convicted of a different offense, or is immune from prosecution. That the actor belongs to a class of persons that by definition of the offense is legally incapable of committing the offense, or that the solicited offense was actually committed. The penalties for criminal solicitation of a minor are: if the actor was 17 and in a gang, then the penalty for solicitation of a minor is the same level as the solicited offense. If the offense was part of gang activity, then the penalty is the same level as the solicited offense. And finally, for all other offenses, the penalty is one level lower than the solicited offense. Just like in the case of an attempted offense, we recognize the need for law to protect society by interrupting a crime before it has the chance to do damage. The second Inchoate offense in the Texas Penal Code is criminal conspiracy. A criminal conspiracy is two or more persons working together to commit a crime. Conspiracy is slightly different than attempt in not only the amount of people involved, but the level of the offense. Conspiracy charges may be applied to felonies only. You can't be charged with conspiracy to commit a misdemeanor. The Penal Code states a person commits conspiracy when, with an intent that a felony be committed, a person agrees with one or more persons they engage in conduct that will constitute an offense and performs an overt act in pursuance of the agreement. It would seem the overt act can include simply mere preparation, which is less restrictive than the Inchoate offense of criminal attempt. This seems reasonable since there are two or more conspirators involved and the state would have to prove both had intent. To this end, the Penal Code states an agreement constituting a conspiracy may be inferred from the acts of the parties. For example, you and your coworker agree to kidnap your boss and either together or separately buy the rope, duct tape, and garbage bags. In this case, a charge of attempted aggravated kidnapping would be appropriate as long as the prosecutor can prove the conspiracy beyond a reasonable doubt through your acts. The Penal Code closes technical loopholes in the statute by stating it is no defense one or more co-conspirators was not criminally responsible for the object offense or was acquitted so long as two or more were not acquitted or have not been prosecuted or convicted, were convicted of a different offense, or are immune from prosecution. So basically, what happens to your co-conspirators in the courtroom doesn't impact you at all, regardless of whether or not they were found guilty, not guilty, get immunity for testifying against you, or even have their cases dismissed, just so long as two or more are not found not guilty. The Penal Code also states it is no defense the actor belongs to a class of persons that by definition of the offense are legally incapable of committing the offense. So, for example, we have previously spoken about this same concept when discussing the law of parties in Texas. A class of people not legally capable of committing an offense are juveniles. Let's say an adult conspires or makes a plan with several other persons who are juveniles under the law to kill another person. They talk about it and even take overt acts, such as buying a gun in order to commit murder. They are caught before they can actually commit the murder, though, and the adult is charged with conspiracy to commit capital murder. The juveniles, on the other hand, are referred to juvenile court for their delinquency, since they can't automatically be charged under adult law with this offense. The adult goes on to argue some of his fellow conspirators are juveniles and aren't being charged with the conspiracy, so, therefore, no conspiracy exists, and he can't be charged with it as well. The law closes this loophole by saying, if you enter into a conspiracy with some people who could not technically be charged with a crime, such as juveniles, it is still a conspiracy. Finally, just like we discussed in criminal attempt, it is not a defense the object offense was actually committed. Again, sometimes charging a completed offense may not be possible because it can't be proved beyond a reasonable doubt in the courtroom. Charging a completed offense as a conspiracy in this situation allows the state to still hold the defendant accountable. For example, a financial crime or computer crime may be difficult to prove, as opposed to conspiracy to commit the offense, which could be less complicated. Just like criminal attempt, all conspiracy offenses are punished at one level lower than the offense attempted. So, for instance, aggravated sexual assault is a felony of the first degree. Therefore, conspiracy to commit aggravated sexual assault would be punished as a felony of the second degree.